to speak a little bit on the H1B lottery result. A lot of people are, curious about how it went. Is there going to be a second lottery? And we're also going to cover solutions to apply for a green card, even without an H1B, for example, from an F1 background. And we're going to talk about requirements and guidelines on other visa types applying for a green card. And we're also going to have half of our session. So the whole session is going to be 1 hour, but half of our session dedicated to a free Q&A with an immigration lawyer. So feel free to ask any questions you want in the Q&A, but please make sure that they're relevant to today's topics. So before we jump in, I do want to speak a little bit about what we are. If you are coming from the Zoom session, from our website, or from Facebook, we are Go Elite. We are a professional consulting agency. We mainly work with universities, and we provide services on day one CPT university consultation and applications. We also help out with F1 reinstatement, emergency transfer, or change of status. Our mission is always to make international students' American dream come true. Our services are free of charge. We provide free consultations and services like that. We are certified by AIRC as one of the first bunch of institutions getting certified. And AIRC is one of the most respectful organizations here in the US. So moving on, we're also on Google reviews. We currently have more than 400 Google reviews. So feel free to check us out, see what other students say about us. And here's all of our socials and our contact information, just in case you need them. So without further ado, I'll let attorney Marta Meng to introduce herself and start the presentation.
Thank you very much, Ryan. Thanks to Go Elite for organizing today's webinar. Thank you everyone for attending. My name is Marta Meng. First of all, let me share my slides with you guys.
All right, perfect.
Okay, great. Thank you. Yeah, it's always a pleasure to be talking about these status issues with the students. And to be honest, today I feel really honored and flattered you guys choose to attend this webinar over watching the presidential debate, right? Which is gonna take place in 30 minutes. So thank you very much for your interest. I'm gonna do a disclaimer first that for everything we discussed today, it's general information. Even though I may answer some questions at the end of the sessions, those are not considered legal consultation. There's no representation relationship established through those Q&As. Those answers are based on the general information provided. All right, so if you are seeking legal advice, that will be have to be based on a written retainer agreement. All right. And everything here is going to be distributed by Go Elite. Feel free to take notes, but we don't distribute it like without prior written consent. All right, thank you very much. All right, so a little bit about myself. My name is Marta Meng. I am the managing attorney at Meng Law Group. We are a boutique immigration law firm. I myself have been practicing for over 10 years now, 12 years. I'm a specialist certified in immigration law by the State Bar of California. I specialize in work visas and all kinds of employment-based immigration petitions. In this process, I deal with a lot of student status issues because when we handle the work visa petitions or the employment-based petitions, a lot of times the beneficiary, the foreign worker sponsored, usually changes status from the F1. So we do deal with F1 status a lot. So if you have any questions, about changing status from F1 into another work visa status or adjust status from F1 to the green card, feel free to leave your questions in the Q&A. We're gonna answer them at the end of the session. All right, so this is what we're gonna be talking about today. Because we probably have like about 30 minutes to go over the topics. So I probably won't go into too much depth for each topic, but I hope after today's webinar, each one of you can at least leave with like a framework to work with. All right. You might not know all the nuances of each work visa or each immigration, like the employment-based immigration petition type. However, I hope you have a good framework about how the green card application process works. What are the key concepts you should familiarize yourself with? So that is goal for today's webinar. So we're going to first discuss what is the green card application process is like, and what are the common options to get a green card, right? And how do you get a green card? And then we're going to discuss what are the common like work visa available to students other than H1Bs. You might wonder like, oh, if I apply for the green card, do I still need to apply for the work visa? We're going to talk about that later. All right. And we're also going to be talking a little bit about the CPT, because I know a lot of you might be F1 student who are currently getting like CPT from your school. A lot of students are concerned about the use of CPT, whether that's going to impact your status right now or down the road when you are changing status into H, L, O, or when you adjust status to the permanent residency. So we are going to be talking about that a little bit as well. All right, let's get started. So first of all, for the green card application, the most important thing to understand is it is independent from your current status. So some people may ask, like, it's very common, a lot of the students would come and ask us, oh, I haven't got selected in H1B yet. I'm an F1. So I cannot apply for green card yet, right? I have to get the H1B first. Or they might be in another status, right? Like they might be in F1, or it might be in a spouse status like H4. Actually, regardless of your current status, you can apply for the green card. All right. You might be wondering like, oh, but a lot of the non-immigrants visas, they don't allow immigrant intent. They are not dual intent, right? How do you reconcile that? Well, you shouldn't have the immigrant intent while you are applying for the visa, which means when you are overseas, doing the interview with the consul officer. However, after you come into the US, spend some time in the US, the person's intent can change. Merely filing an immigration petition wouldn't mean you are violating your current status. So just because you're filing an immigration petition doesn't mean you're going to lose your current whatever status it is, like be that F1 or be that F2 or another status. So those two things are independent from each other. Right? So you don't have to ask like, oh, do I have to be in this status in order to apply for this green card? You can apply for the green card through whatever path that you're eligible for, but it has nothing to do with your underlying status. All right. Okay, so that's the first thing to understand. Like whatever, all these green card options are available for those can meet the criteria regardless of their status, current non-immigrant status. All right. And the green card process, even though we talk about green card application as if it is a one-step process, like, oh, I apply for the green card, right? But it's not really as simple as that. The actual filing for the green card is done on a form called I-485. So that is the application for permanent residency. By filing that application, you are officially telling USCIS that from this point on, I request to change my current status into the permanent resident status. I'm making that request, all right? So when the I-485 form is approved, you will officially be a permanent resident. You are no longer an F1 or an H1B anymore. So the filing of the I-485 would be the official application, the actual filing for the green card, right? What is the requirement for filing I-485? It just means like you have to have a lawful status, like non-immigrant status right now in order to file. All right. So you might wonder like why people wait, right? Like, can I just file I-485 right now? No, the I-485, it cannot be filed on its own. All right. In order to actually file this application for the green card, you have to have one thing called immigration petition. What is a petition? Well, you can think of it as like the condition for you to file for the I-485. All right. The condition is for the USCIS to see the why. Okay, why can you file the I-485? Tell me the why. Okay, the why can be, okay, I have a qualifying relative. All right, my spouse is a US citizen or my spouse is a green card holder. So I have a family member, thus I can qualify to file for the application for the green card. Or I have a willing sponsor, a willing employer who's willing to sponsor me for the green card. So that's going to be employer-sponsored petition. It can also be some self-petition, like I am a highly achieved individual. I can petition for myself. All right. That can be EB1A, that can be NIW. All right. Or I self-petition because I am an investor. Okay, I invest certain amount of money into the US and then I'm creating jobs. All right. Also, it can be, you are an asylee or you're, the recipient of a diversity like a visa. That can be it too. But those are not as common as the family-based and employment-based petitions. So that's going to be the focus of today's webinar, today's discussion. Right. So in order to understand that, we need to also understand, okay, there is the petition, the immigration petition explaining the why. Why should the immigration agency allow you to file the I-485, which is the application for the actual green card, right? So there is the petition. But like, can they be filed together? So after the petition is filed, or approved, can I file the I-485 immediately? Well, not always. It depends on what kind of petition you're filing, or others are filing for you, and what is your country of birth. All right. I know for today's webinar, a lot of you may come from countries such as mainland China or India. Some of you might already be familiar with the idea of the visa bulletin. All right. So that is a very important chart that is released monthly by the Department of States that tells you if you are eligible to file the I-485 or not. For those of you who are not familiar with the visa bulletin yet, then this is something you probably want to study after today's webinar. Okay, familiarize yourself of the visa bulletin. Right. So after filing the petition and getting that approved, a lot of times you might not be able to file the I-485 right away. You have to wait. Okay. Wait for what? Wait for your priority date to be current. That is like a legal jargon, like a legal terminology term that used in the immigration context a lot. I would think of it as like a number. You can think of that as like a number in the line, right? So if you go to anywhere, like if you go to DMV or you go to, wherever to like a lot of the government agencies to do something, first of all, or a hospital, right? You're asked to take a number first, right? And then you wait in the lobby. And then as soon as your number is called, then you go to the window and you start doing whatever application you're filing for there. So think of the priority here as the number you're taking. All right. And think of the filing of I-485 as when your number is called and you're going to the window to do the actual filing. All right. So how do you get that number? How do you get that priority date? By filing the immigration petition. All right. So by filing the immigration petition, you're going to get a priority date. That date is the receipt date of the immigration petition, whatever it is. It can be the family-based petition. It can be the the employment-based petition. The only exception is some of the employer-sponsored petition through the labor certification. So it is not the actual petition date that is the priority date. It is the filing of the labor certification, but that is an exception. That's some nuances there. Most of the time, it is the filing of the petition that determines your priority date, which in a way is your number in the line. All right. So in order to get your things done in the line, what is important, right? To get a number as soon as possible, right? If you see a long line there, and then you probably want to rush to it and get a number first. All right. So maybe some of you would be thinking, all right, how about I just file a petition right now, right? File that as soon as possible. Well, if the petition is not approved, if it is ultimately denied, then your number is canceled. So your number doesn't work anymore. So it is very important you not only file the petition as soon as possible, but also get that petition eventually approved so your number won't be void. It can be a valid number. All right. So that is how it works. File the petition, get it approved, waiting the line, waiting for your number to be called, and then file the final step, which is filing the I-45. So that is the three phases of the green card application for most of the categories. All right. For some of the categories, like some of you may have a US citizen spouse, all right, at some point maybe, then you might be like, oh, but is there going to be something different for like the US citizen spouse? Yes, the difference is there is no this middle step for like say the immediate relative for US citizens, like US citizen spouse. For them, it's always current. So there is no this wait time in the middle. But for most of the other categories, like especially the employment-based categories for mainland and Indian board applicants, there is wait time. So let's look at the wait time and how this thing works. Okay, so I am showing you the visa bulletin for July 2024, the employment-based categories. All right, so you can see here there are different categories listed, first, second, third, and fourth. All right, in order to understand what those means, I'm gonna briefly introduce what they are. So for the first, it refers to those EB1 preferences. Within the EB1 preference, there are three subcategories: EB1A, EB1B, and EB1C. All right. For the EB1A and EB1B, they are targeting, like they are for those who have extraordinary abilities. EB1A is self-petition. So you can be from any field. It can be from science, education, business, art, a lot of those various fields, as long as you can show you are someone of extraordinary ability in the field. How do you prove that? There are 10 criteria. You have to at least meet 3 out of the 10, and then show that overall you are the very top of your field so that you are qualified under EB1A. EB1B is kind of different. It has to go through a sponsor. It has to be employer sponsored, and you have to be an outstanding researcher. So you cannot be from art or business, right? Because this is for researcher only. But the kind of like the reasoning is the same. Like you have to show like you meet 2 out of the 6 criteria first. And then overall, you are at the very top of your field. So that is EB1A and EB1B. EB1C, that is for multinational managers and executives. So it kind of becomes more common these days, like say for a lot of the multinational companies, they might send some of the employees overseas be there in a managerial or executive position for at least 1 year and transfer them back. But the trick here is you have to have 1 year of the qualifying experience. The qualifying experience is a managerial or executive position. You have to have that 1 year qualifying experience in the 3 years, all right, preceding the filing of the petition, or preceding your entry as an L1. So that means if you have been studying all this time in the US, you probably won't qualify unless you're willing to leave the US and spend at least 1 year at an overseas company, if assuming your company has a qualifying overseas parent, subsidiary, or affiliate office overseas, all right? And then come back to start the EB1C process. So it requires foreign work experience. All right. There's also the EB2, EB3, which is the most commonly used green card, like the immigration petition for international students. Those are through the employer sponsorship. But the employers would have to show that they have tested the US labor market and there is no minimally qualified US workers for the position, which is pretty tough given the current labor market, right? As you might have heard, a lot of the big tech, they have already stopped sponsoring people through the perm because it is very hard to show that, especially some of them may have had layoff lately, right? And then some of them might be afraid of the DOJ investigations, like, both the Facebook, now Meta, and Apple. They all faced some investigation from the government agencies, right? So they don't want to get into trouble, so they might not sponsor. But this is still, so far, the most commonly used green card application option for international students through the employer sponsorship. All right. And then there's a subcategory of EB2 called a national interest waiver. I would say it is, kind of like another version of EB1A, but is less strict. All right. You still need to show you have some unique contribution to the field, but you don't have to show that you are at the very top of the field and meet 3 out of 10 criteria. What you have to show is you would bring, national interest if the USCIS grants you the permanent residency, grants you the green card. It doesn't have to be STEM major. We have seen a lot of people from other non-STEM majors, including artists, who can qualify under a national interest waiver, NIW, as well. However, you still need to show like you have some uniqueness in what you do. All right. Like say, for example, you have some papers, or you have some patents if you have no paper, or maybe you have neither patent or papers, but you have a lot of conference speaking, experience. Or for artists, they might have some exhibitions, right? They might be participating in some productions that have pretty good feedback. So you still need to show the impact of your individual work in some way. So if, let's say, a lot of the students feel like, oh, I have been working for this really big company for this many years. I have done a great job. Can I apply? Well, not always. It depends. But without anything kind of tangible to show your individual impact, just because you're working for a very famous company, that thing by itself doesn't qualify you under NIW. All right. I do notice a lot of the applicants might have some misunderstanding about NIW because it doesn't have very specific criteria as EB1A does. What it lists is like the advanced degree. So a lot of people may consider this to be too easy. Like as long as I have a master's degree or a PhD degree, I can qualify under NIW. Not always. It still depends. All right. And then there's the EB5, the investor petition. All right. Right now, this is also a very interesting category because that is the only category that doesn't have any visa backlog right now. which means there's no line. You can file your petition concurrently with your I-485. If any of you is interested in this category, we can talk a little bit more about it during the Q&A, but I'm not going to go into too much depth right now. All right, so hopefully you have like some ideas about what are the common options to apply, to do the immigration petition. All right, and then this is how the line works and how the line and the number work. All right, this is a chart for July this year. So the first, the second, third, fourth, and fifth, you can see there are 4 different subcategories. You don't have to know what they mean. Just know all these stand for EB5. All right. So they stand for the EB 1, 2, 3, 4, and 5. And depending on your country of birth, all right, if you were born in mainland China, you might want to look at this column. India, you might want to look at this column. All right. What if you're from other countries or areas? You cannot find the country listed here. Then it's going to go under this worldwide. All right. The first column. So if you are applying for let's say through the EB2, EB3, all right, your employer is doing the immigration petition for you, let's say EB2, all right, then you look at the second, and depending on your country of birth, you can see a date, all right, so that is the date, that is the priority date called in July 2024, all right, let's say for mainland China, in July 2024, those who file the petition back on March the 1st, 2020, they can apply for I-485 in July. All right. And then if you look at India, same category, same EB2, those who file with a priority date on June the 15th, 2012, can file I-485. So that's how it works. All right. Unfortunately, you can tell for a lot of the immigration, like the employment-based immigration categories, the date for China mainland-born and Indian-born is much earlier than other countries, which means there's a longer line there, right? That's because for under immigration law, there's a per country limit for the each category. That is why, for some countries, unfortunately, it just takes longer to get the green card. So what happens while you're waiting then, right? We talked about this process. So if I file the petition, I get a number, I have to wait until my number is called in order to file for the I-485. But it looks like my number, it may take a few years to be called. Then am I legal to stay here just with this petition? Unfortunately, no. Petition itself doesn't give you any lawful status to stay, right? You still have to maintain your own underlying non-immigrant status to stay in the US lawfully. That is a condition for you to file for the I-485. If you lose your lawful status, if somehow you fall out of lawful status, most of the time, unless, there might be some exceptions, let's say US citizens spouse, right? But for all of these EB categories and the green card spouse, you have to be in the lawful status when you file the I-485. Well, there are some exceptions. For example, for a lot of the EB categories, if you are out of status for up to 180 days since the last entry, it still can be waived, but we don't want to talk about those exceptions today, all right? You should do your best to maintain your lawful status at the time of filing for I-485. That is a condition for you to follow it. If not, then your I-485 may be denied. Then here's the question, how can you maintain the lawful status until you file the I-45, right? That is the question. Like after graduation, you would all get like 1 year OPT, right? Some of you may get 2 more years if you're in a STEM major. But after 3 years, if you cannot get selected in the H1B, then what? How do you have a lawful status? Well, that is very unfortunate. Like these days, H1Bs are so hard to get. Some other very common options would be like say O1A and O1B. I do recommend you guys look into the O1A and O1B because the Biden administration has done quite some policy updates, try to kind of relax the criteria that a little bit. So for those of you who are unfortunately not selected in the H1B, see if you can get that under get a work visa under like O1A or O1B, right? Or some of you may get sent to may get option to be working at an overseas company, an office outside the US, right? And then come back on L visa. That is also a pretty common practice for a lot of the multinational companies. Other than that, if you work for a nonprofit, right, then let's see if your organization, your employer might be qualified for the cap exempt H1B. Not all the nonprofit qualifies for it, but a lot of them do without realizing it. We just had a case that is a nonprofit that does service to some of the minority groups. They don't consider themselves as a research organization, but actually they did qualify for the cap exempt like H1B because of the working relationship they have with all these universities. So some nonprofit may not be realizing that. So that is also something you can look into. But I know a lot of you might continue studying, right? Like, okay, if I cannot work here right now, then I just continue studying, right? And while studying, a lot of you may consider using the CPT, which allows you to do some practical training, right? So you're not just staying in school on the ivory tower, and you also get some hands-on experience. But I know a lot of you do worry, would that be a problem? Because they're having all these discussion about whether CPT can get you into trouble or not, right? Overall, this is something based in the regulation. So it does have its legal authority. However, it does have the potential to be abused if you're not using that properly. If some of the schools are not using that, like issuing that properly, right? So some of the common issues comes from whether you are still a full-time student, right? You cannot completely drop out the school and just do the training, right? You have to still be a full-time student. And whatever you do during those practical training has to be related to the major you study, right? So those are the two most important issues you have to deal with. There have been some recent trend from USCIS, kind of discussing whether you are enrolled in online classes, which doesn't qualify you for the full-time course of study. The definition of online class is pretty restrictive under the current regulation. So basically, as long as that class requires some physical attendance, it's technically not online class. So only if it's completely online, then that is online class. If it requires some level of physical presence, then that's not. So that's why some schools may still be using some hybrid mode to allow some students to, be a full-time student. But, this is an area we'd like to monitor very closely because there seems to be, some room that is up to USCIS for interpretation. But again, like the most common issues that USCIS care about is full-time student, and whatever you do should be related to your major. All right. So I hope that gives you a framework to work with, and we can probably look at the questions now.
All right, thank you so much. We do have lots of questions, so I'm gonna share my screen and we're gonna jump right into them. All right. Can you see my screen now?
Yes.
All right. Okay, let's go. We do have some questions asked regarding day one CPT. I'm happy to answer them. But if you want, the immigration attorney to jump in, that is, totally great too. So, first question, I'm from India. Can I do day one CPT masters in the US? I think this person is probably asking from like a legal standpoint. Is this allowed to coming straight from India to do day one CPT?
Well, if you're asking about applying for a visa at the consulate, then it doesn't really matter whether this is a day one CPT master in the US. Like the officer, the visa officer would care about whether you're, first of all, whether you're a bona fide student, whether you're really coming to study temporarily, right? And also your ties to your home country. So that's usually what the visa officers care about.
Mm. Yeah, if for those of you who are listening right now, if you have questions regarding F1 visa in general, we do are having regular webinar sessions with former F1 visa interviewers too, visa officers. So scan the QR code, we'll keep you in touch, and when we get another webinar at the F1 visa, we'll let you know, and we're lucky to have you back with us. So ne next question, can I apply for day one CPT while my change status application is pending? So I'm doing a change status from F1 to H4, but my OPT is ending soon, so I wanted to continue to work.
So if you're changing status from F1 to H4, you can still have the day one CPT. I mean, the CPT, if your school, allows you to do that. But as soon as your H4 is approved, then you're no longer in F1 status. So the CPT is something that goes with the F1 status. If you are no longer in F1, you're in F4, H4, then you won't have CPT anymore.
Moving on. So third question, my OPT from my master's program expires in September. Do I qualify for day one CPT? I can answer this one. The short answer is yes. So after your OPT ends, you will still have 2 more months of grace periods. So technically, if you enroll and transfer to the day one CPT school before November, you have the legal status. All right, let's go to the next one. Can we have multiple day one speed degrees while waiting for I-485?
Well, that still comes down to the question whether, first of all, whether you have been maintaining status all these years while you are in F1 status before you file I-45. And second, like, if USCIS looks at this, right, they might question like whether you are a bona fide student, right? Why are you doing all these degrees? Do you have a reason? Like if you like repeat like the program, like you have done this program once and you're doing the same program another time, that doesn't sound like that doesn't look like you are a bona fide student. So it really depends on, each individual's circumstance, whether this is something that makes sense for you to be a student. So whether this is a day one CPT program or not, it really has more to do with the program. Like, why are you choosing this program? Is this mainly for the academic reason? Are you really, there to be a full-time student to study? So that is the most important to stay with the intent for the F1 status.
Right. I think this also well put, and I think this also answers the next question we have, which is what do we do to avoid being denied or questioned about similar master's program? I think long answer is short. Sometimes you couldn't avoid, getting questions for, duplication into master's degree. That's we wouldn't recommend you to do a similar or the same master's major once again. Right, moving on. Does having a approved I-140 or submitted a DS-260 affect the application for a new F1?
So that really depends on what you mean by a new F1. So if you are talking about here in the US transferring into a new program, or even apply for OPT after graduation from the program, then those petitions or DS-260s won't affect. USCIS actually clarified that this year through some policy update. Merely filing an immigration petition won't um, won't affect, the person getting OPT or even like changing status into F1, as long as you can show, you still have these, other like factors that can be weighed like favorably for you. However, if you mean a new F1 visa, like at the consulate, like when you're at a US consulate in China, in India, that would be different because the US CIS policy doesn't apply to the consular officers. They are still bound by their own guidance, which is the Foreign Affairs Manual. And the consular officers, they have a lot of discretion to give, grant, or deny a visa based on how they interpret your immigrant intent or not. So if you are applying for F1 visa, I would say that would definitely be like a factor that can affect your chance of getting the visa.
Right,
But
right.
it's not impossible. It still depends on the circumstance, like how long this person has been in the US, how many programs have you studied, right? Is this the first time you're applying for an F1, or you have already done 3 programs and now wants to get F1 again to do a fourth one? All those would affect the chance.
Yeah, for sure. Moving on to the next one. If my I-485 got approved, can I go back to my home country to wait, or is it required for me to stay here for a duration?
If your I-45 is approved, then congrats, you're a permanent resident. Then you can travel without having to worry about visa anymore. Then how to maintain your permanent residency is a separate topic.
Mm.
But basically, as long as you can show you have the like the intent to stay in the US permanently, then you can maintain your permanent residency.
Good to know. Let's go to the next one. So this one is more is longer. So if I reach the 6 year limit on H1B and then I switch back to F1 to study, then I get the I-140 approval through another employer other than the one that I did with H1B. Uh, um, and I leave the US, apply for a new H1B visa. Uh, Even though the previous H1B has expired, is that allowed?
That is allowed, that is possible. But what I want to add is you might not have to leave unless you want to. If your priority date is not current, then after the approval of the of the uh, of the second I-140, or even without the approved I-140. If your priority date is not current, you can still extend your H1B, right? Assuming that your priority date is already current, so that you cannot extend H1B beyond the 6 year limit. And then after the second I-140 is approved, then you can just adjust status in the US. You don't necessarily have to apply for a new H1B visa.
Hmm, absolutely. Next questions. Is it a good option to pursue a second day one CPD degree if I already have one, uh, but still didn't get the H1B yet?
Well, again, like this is not something like legally prohibited. There's nothing in the regulation that prohibits you from doing this. But whenever you enroll in a program, right? How do you show that you are a bona fide student? Like whenever you choose to enroll in a program, you still bear the burden to show that you are a bona fide student. So that would be case by case.
Yeah, for sure. Moving on. If I currently have OPT until January, I think next year, I'll start a new program with Day One CPT on January. Could I just continue working or do I need to wait?
It can get a little technical here because when your last OPT ends and when you are starting a new program, as long as you are transferring from your current school into the new school, then your OPT ends. All right. So when that transfer takes place, your OPT would end. All right. And then only after you are starting at the new school and the new school DSO grants you the CPT I-20, you have the work authorization again. So technically, there could be a small gap during this transition. It depends
Right.
on how you structure it.
Right. So, in general, we would recommend students to get prepared for your CPT application as well as the CVIS transfer earlier as you can, because understand both of these process might take time. And you don't have to wait, you know, without working during the enrollment process. So you can still work under your OPT while you're getting the offer letter, you're getting, you know, the CVIS transfer prepared. But once you get everything prepared, it should make both of these process smoother and with less time as possible. So the gap time might be just a day or two in the best case. So moving on, what are the chances of a second lottery for H1B this year?
Well, we don't know yet because this is the last week of the filing window for those were selected back in March, right? Um, most of the practitioners, most of the immigration attorneys believe for this year, the chance of a second round of lottery is very, very low because this year the system has changed. The online registration system changed to the beneficiary-centric system, right? So there really is no reason like some of them do not proceed to filing, or even there might be, it shouldn't be a large number. So we don't really expect to see a second round of lottery this year, but we never know until USCIS announces like whether they have filled the cap or not.
So when should those announcements usually come out?
If there is a second round, usually that's announced in either July or August.
Mm, all right. Moving on, my person wanted to ask, can I use Day One CPT in the same school with different programs? Um, could you share a little bit insight on that?
Well, basically, we're talking about someone taking multiple programs with the same school, right?
Hmm.
Then if that is the case, then again, it comes to why. Like, are you doing programs at different educational levels? Like, say, for example, you did bachelor, you did master, and then you did doctor degree. That kind of makes sense, right? That there's nothing wrong with that. Or maybe you did like master in certain major and a master in a different major at the same school. That is also pretty common, just not thinking about the CPT at all, just from a program selection perspective, that's pretty common too. But it's really about why are you doing, like why are you choosing that program? So it's possible to do multiple programs at the same school, but it is your reason that matters.
Yeah, absolutely. Moving on. So my OPT ended already and I have applied for a B2 visa. Am I allowed to overstay while the new visa is pending? Uh, if my OPT grace period ends. I think this really depends on if you file for a change status.
Hmm. Yeah, I'm not sure what this student is asking about, like applying for B2 visa. I assume you're talking about filing the I-539 to change status into B2. If that is the case, yeah, you can stay in the US while waiting for the change of status to be adjudicated, even past June the 4th. But you get 60-day grace period following the end of the OPT anyway, right? But if your change of status is not adjudicated within even that 60 grace period, you're still authorized stay. But just remember for the I-539 change of status into B2, the maximum you can request would be 6 months. So you really have to make some plans for yourself, after the 6 months. If your plan is to depart the US and leave the US, then that would buy you some time to wrap things up. That's not a problem. But if at that point you change your mind, you decide to stay, then that is something you should plan accordingly, like when you should file maybe another status change and whether that's possible or not.
Yeah, absolutely. I am from India and I have a B visa that is expiring on October. If I get sponsored by an employer, can I continue staying in here? I think sponsorship needs clarification too, because you can get sponsored for different kind of things. But just assuming that if the person gets sponsored any forms of a green card.
Right. As we discussed over the first half of this session, um, if it is sponsorship for the green card, it's gonna take quite a few years until you can file for the I-45 if you were born in either mainland China or India, or even other countries now, like even worldwide EB3 has backlog right now, and EB2 as well. So if you mean sponsorship by an employer for green card, then you cannot stay just because they start the process. If you get sponsored by an employer for some sort of work visa, that is possible, but what type? What type of work visa, right? So we just discussed like the H1B, usually it is subject to an annual cap, so you have to go through the lottery. You probably have already missed like this year's like lottery registration window. For the L, it requires foreign experience. For O1, that seems to the only option left, but it has requirement about the beneficiary, this foreign worker's own professional achievements. So there are not that many options available for sponsorship.
For sure. Next question is actually a very good one. If I work with Day One CPT for a company for more than 1 year, uh, would I lose my eligibility for STEM OPT?
So first of all, in order to have STEM OPT, which is considered OPT extension, you have to have OPT first, right? And you can only have OPT following your graduation if you haven't used up the 12 months OPT at the another program at the same education level. So for example, if somebody has already done master in a non-STEM major and now they are doing another master in a STEM major, you cannot get STEM OPT because you cannot get the 12 months initial OPT to begin with. So you cannot get the OPT STEM, like STEM OPT extension, because there's nothing for you to extend, right? So you have to be able to get the initial 12 months OPT first. Let's say if you can get the initial 12 months OPT. This is a program where you haven't used any OPT in the past at the same educational level, then you cannot be working in CPT full-time for a year or more. Otherwise, you're going to lose your OPT completely. But if you work part-time, which means fewer than 20 hours a week, then you for the post-graduation OPT.
Sure. Um, I think we are about time to wrap up. We're gonna do one more questions. And thanks everybody for coming in today. I do know we have other questions we haven't answered yet. So scan the QR code and talk to our consultant. We're happy to resolve any questions you have. If we couldn't, we will refer you to the attorney so you can have more in-depth conversation with her. And so last questions, I'm on H4 dependent visa, just got to the US. If I join F1 CBT University, uh, can I start working full time or is it part time? And also, am I eligible to apply for I-4 85?
As to the first part of the question, well, yeah, you can change status into F1, whether the school would issue you day one CPT or not. That really depends on the kind of program you're choosing. Usually those, since you are currently on F4, H4 and you just arrived, then I would assume that should be some sort of advanced degree, like a master's degree, right? And the CPT should be really an integral part of their curriculum for them to issue the CPT right after you start at this program. Whether you can apply for I-45, that I don't know what is the underlying like petition for your I-45. Are you filing that because your spouse has a petition that is becoming current? If so, then yeah, of course you can join your spouse in the I-45 application. But if your spouse already has an immigration petition that is current, or is about to be current, I would probably want to ask a little more like, is that an I-140? Is that like an employer-sponsored I-140? Or is that like a self-petitioned I-140? Because if your spouse has an approved I-140 as an H4, you can just apply for the H4 EAD. You don't have to, you can just work with the H4 EAD right away. So that is also something we need more information about.